Welcome back to the OMB Law Board. I'm Simon Bennett. Today I've got Jennie Goff, a special counsel in our litigation department with us. Jennie, welcome to the OMB Law Board.
Thanks for having me, Simon.
So Jennie, when we look at compensation, we talk about property compensation where there's damage to goods or vehicles or what have you. And then we talk about compensation in respect of damage to person or injury to person. And I think that's what we want to talk about today.
That's correct.
Okay. So I know there's a bit of a concept that quite often people don't think they're going to need a lawyer. They can just sort it out themselves.
That's correct. And I don't know why that's the perception. Sometimes people think there may be a bit of mistrust as to what they might get from a law firm. Sometimes people think perhaps they've got an idea of what they need to do themselves. They can run it themselves. Sometimes they just think it might be quicker, better outcome for themselves. That's not always the case, though, and that's what we wanted to sort of go through today.
Okay, so from my personal perspective, I would have no idea how to go about the process of making a claim as such or what is required. Maybe you can run us through sort of why it's important to get qualified legal and expert legal assistance in this and you know what that process, what it is you undertake to make a claim on someone's behalf.
Yeah. So look, I think the best way to look at it, often people who have another legal issue, they may want to buy a house or they do, as you said, have a dispute with property. They will come to a lawyer quite readily. It's the same premise when you have some kind of injury that has befallen to you. Legal advice is important in that aspect just as much as it is in any other legal framework. Someone will have an injury. Now, that could happen through a multitude of reasons. They could be in a motor vehicle crash. They could have an episode or an incident at work. They could have something out in the public forum where they could suffer an injury. It's really important to seek some advice or have some legal understanding in respect of that, because you can't just bring a claim for a pure accident. It has to be an event where there's been some kind of negligence or fault. And that's the starting point, getting some good solid understanding of whether you do have the capacity to bring a claim. Because if you bring a claim and you don't have that, it's a time waster, and you'll only come up against an insurer who basically shuts you down, and they might have a reason to. So good solid advice in the first instance. Do I have a claim? What does that claim look like? What are my potential timeframes? What can I claim for? People who maybe run it themselves don't have a full understanding of what they can claim for.
So you hit on an interesting topic there. There is timeframes.
Absolutely.
So what do the timeframes look like generally? I mean, I know it's case specific.
It is.
Give me an outline of.
Okay. Probably the most recognised timeframe and arguably a very important one is usually in a personal injury matter, you have 3 years from the date of the accident or the incident or whatever the injury is. That's your usual time frame.
Right.
It's a fairly rock solid time frame. However, very special and limited circumstances, it may differ, but they are very limited. So that's usually your big time frame that people may be aware of and may be bandy about. However, in saying that, with injury matters, there is a pre-court process in Queensland that you must progress through in most instances, and that has other smaller earlier timeframes that you have to be aware of. They're perhaps not as strict as the 3 year, but they are certainly timeframes that if you don't hit them and don't meet that mark, it can make your claim or your ability to claim very difficult.
Yeah. So you've gone to see your lawyer, you've determined that you've got a claim or you've got high prospects of success of having a successful claim. What next?
Well, there's quite a lot of early involvement. These claims can be very heavy-ended at the start. So you're right. Do you have a claim? What are my time limits? That's one of the first things you look at. Then you say, who am I bringing my claim against? Is there one insurer? Is there two insurers? Are there potentially 3, maybe 4, 5 insurers? You've got to identify who the person is, or the people or the company that you are bringing a claim against. That sometimes can undertake some investigation, which a law firm is really well placed to undertake for you. We've got resources, we've got the know-how. So identifying who you are bringing a claim against, identifying the correct legislation to bring it under. There's a multitude of legislation and pieces of legislation out there depending on what your claim is. So your initial claim form, getting all that set up, then basically undertaking evidence collection. What evidence do I need? What injuries do I need to prove? What loss do I need to prove? So all that information gathering, and in Queensland, that has to be done in the pre-court phase before you ever even get near a courtroom.
Okay, so I've gone through the process. I've determined that I've got a claim. I've determined the party that I've got a claim against, and then I need to put together the evidence to prove my claim and to prove my damages.
Yes.
Which can be quite substantial.
It can be. And look, we talk about heads of damage in our industry. There's multiple heads of damage. I think the most noted head of damage that people know is what they call their pain and suffering. You know, that's the injury that's to me. That's what people recognise most, but there's a myriad of other items out there that people don't even know that you can claim for. You can claim, obviously, for if you're employed and you can't be in the workplace for any time, you can claim for that loss, both in the past and into the future. You can claim for any expenses associated with your claim, whether it can be as simple as travel, or maybe you've had to engage someone to do some services for you. It can be loss of superannuation. It can be equipment or any other resources that you may need to assist you move on now that you've suffered a particular impediment. There's certain ways you can claim that, but importantly, you cannot claim for anything that you actually can't prove loss of. Losses must equate to provable loss.
So we get to that point. As you said, all this is done pre any sort of court appearance.
Correct.
And then there's some compulsory conferences that you have to undertake. Let's dive into those a little bit so that our listeners understand how that works.
Okay, so when I talked about the pre-court phase, in Queensland, and the purpose of a pre-court phase is to try and keep people out of courts. Courts are expensive. It takes away the ability for people to negotiate and have a more of a known outcome. It takes away, courts take away the ability of people being able to have a relationship continuing with the other party. So there's many reasons. So the way the court system in Queensland runs is we must have a compulsory conference before we can move on to the court phase. So that is, as I said, information gathering, having your procedure and all your evidence ready to a compulsory conference stage. And that's when you get an opportunity to come with your lawyer and the other parties, depending how many there are, into a fairly informal environment, but it still has rules that we must follow. And you get a really good chance to try and resolve the matter at an opportunity where you still have some say, and at an opportunity where it's less stress, it's an early opportunity, so you don't have the time rigours of a court proceeding, and where you still have some control in the outcome.
And who would usually likely attend this pre-court conference?
Okay, so always the person who's injured. It's a goal for them to be there and to participate, but at a level that's comfortable for them, and it's always open for negotiation, and it's depending on what the client is comfortable with. However, you are represented by a lawyer. Usually you would engage a barrister as well, and that is someone who is specialised in advocacy, who can really present your case well. As I like to say, it's the icing on the cake. Your lawyer is often building the cake, preparing the cake, has the intimate knowledge of your claim, and at a conference you may engage a barrister to really be that icing and to present your case and be the absolute advocate for you. They present your case, you then hear from the other side, and it's a really good opportunity to understand the strengths and weaknesses of your case. Litigation is never without risk. You may have the best case in the world or think you have the best case in the world. However, there is always a risk that there is some weakness or loophole, and it's a really good forum for you to hear that and then make a really informed decision as to whether or not.
And is there an independent mediator there?
Occasionally, normally at the first instance, particularly if it's one party and it's a more regular matter, no mediator. It's just two parties trying to nut it out. However, if it's a case that's maybe a little bit more involved, maybe there's 3 or 4 parties and there's going to be internal arguments between the various respondents, you may then engage and agree to engage a mediator.
Okay. Thing I like about the mediation process is generally you go there with no real downside. The worst that can happen is you walk away without a result. but any result that you get, you will have agreed to. So they can't force the result upon you. You'll have to agree to it. It's within your control.
Absolutely.
And you've also got a bit more flexibility to come to a result that a court couldn't order. So a court might be limited in what its remedies available are.
Absolutely.
But at a mediation, you've got a bit more flexibility.
And that's it in a nutshell. Conference mediation is all about flexibility. It's about you having some control. At the end of the day, it's your decision. You get advice, and you will get that advice from your lawyer, from your barrister, but it's your decision at the end, based on the advice you're given. It's also an environment where costs and the risks associated with costs aren't available to an insurer. It's like we call your opportunity to have a negotiation risk-free with usually no cost consequences.
And if you don't get a result, then you'll proceed on to the court?
Yeah. So again, timeframes come into it. At the end of a compulsory conference, parties have to provide their best position. Those positions are available for a certain period, and then after a certain period of time, proceedings can be commenced, and then it goes down the court process. There's certain structures, timeframes that we have to adhere to. That goes along that timeline. There is, of course, always opportunities to try and have another negotiated outcome, perhaps through a mediation, through discussions between your legal teams. And that's really important, to always have that open mind to keep those discussions happening. Even though you are in the court process, matters rarely go all the way to court. Most opportunities come up, and you do have time to try and have further negotiations, which is always, in my view, the best opportunity to have an outcome without taking away, some control for you, which is what a court does at the end of the day.
Jenny, thanks for unpacking the process of that personal compensation as a result of an injury for us. I think it's, given me a little bit of insight as to that procedure and what we need to look for, and why it's really important that you seek expert advice. And obviously, for our listeners, viewers, Jenny and our litigation team are experts in this area. So any queries or concerns, drop us a comment in the link below, or phone Jenny and her team, because I think an opportunity can be lost without receiving that expert advice.
Absolutely. And, you don't want to be in that situation where you've got a real David and Goliath type scenario. You don't want to be David and be up against an institution that has a lot more resources, experience, often in-house lawyers. It's better to have someone in your back pocket who can help you negotiate and manoeuvre through that whole scenario, and also at a time where it's quite stressful for you.
Yeah, absolutely it is. Well, thanks for joining us today, and look forward to speaking to you in future podcasts. So,
absolutely.
And thank you for joining us and listening all the way through today. We look forward to seeing you on the next episode of the OMB Law Board.